Today's talk is about the cost of waiting, going off piste under a voyage charter. What happens if extra contractual instructions are given by the charterer to the ship owner? Now, most modern voyage charters, at least many of them, have now got provisions allowing the charterer quite a degree of flexibility as regards the loading and discharge ports and the rotation of them through renomination clauses and interim ports clauses. What is the position, though, if charterers give an order to the ship owner that falls outside these clauses? An example might be an order to proceed to a place to wait for orders. Now, this is the thing which happened in the Jasmine B. There was an order given by the charterers on the 25th of May to proceed immediately to US East Coast, New York for orders. The order was a direction to the vessel to go to a specified location for orders, and it wasn't a change of discharge port, which is what was provided for in the particular clause there. Now you might say, well, if you're going to change your discharge port, you're going to probably need to go to a specified location from where you are then going to give the orders to change the nomination of the discharge port. But that type of conduct outside the scope of the permission of the clause. And Judge Diamond, QC, says, I reach this conclusion with some reluctance. Says there is obvious commercial convenience in a clause which entitles a charterer to change a nomination for discharge port for the nomination of an area to which the vessel must proceed for discharge port orders. So it all depends on what your clause allows you to do. So what's the consequence for the relationship between owners and charterers if a non-contractual instruction is given by the voyage charterers and the ship owners agree to follow what the charterers have asked for? We go back to Stevens and Bromley back in 1919. There's a charter there to carry a cargo of steel billets, and charterers loaded a full cargo, which was partly made up of steel billets and partly of general merchandise. So they had loaded some extra contractual cargo. They got extra freight on the basis of a quantum meruit. The ship owners get extra freight for this non-contractual service, the loading of a different type of cargo. So we're looking at quantum meruit. We're not looking at any breach of contract by the charterers. We've got essentially a request by charterers to do something outside the scope of the voyage charter, which the ship owners then agree to, and there's an implied contract, and there will be a reasonable sum awarded to the ship owner by way of quantum meruit for carrying out these additional services. So there's no question of the charter actually breaking the contract. You've got the request from the charterers, and if the ship owner agrees to it, that generates an implied contract with remuneration for the extra service on a quantum meruit, reasonable sum basis. An example of this is Saranikos back in 1986. The vessel's chartered for the carriage of bag sugar from Antwerp to Aqaba. At the charterer's request, the vessel waits off Aqaba for about 9 days to resolve problems that have arisen over the sale of the cargo. Now, this is not a question about any breach of charter. It's not a question of showing whether there's been any loss suffered by the ship owner as regards following this instruction. The judge says, I prefer to approach the question of remuneration by asking simply, what would be a fair commercial rate for the services provided outside the charter party? That is to say, for the owner's agreement to the use of the vessel as, in effect, a mobile floating warehouse off Aqaba. You've asked us to wait for 9 days off Aqaba. We've agreed. Now, pay us for that. Implied contract, a reasonable remuneration at the fair commercial rate for those services. And what you get, that reasonable remuneration, is the bunkers consumed during that time, daily running expenses, plus the profit the vessel would have made at the market rate. And there was evidence that the vessel would have been able to make profit out of the then market rate for such vessels. Now, many detention claims involve assessing the damages at the demurrage rate. Now, this is not the same as what was awarded in the Saranikos, which is running costs plus profit based on the market rate. Demurrage would encompass both elements, and if you calculate the reasonable remuneration by reference to the demurrage rate, you shouldn't really be awarding any additional bunkers. In this case, it would be what are called hotel bunkers, the non-propulsion bunkers, which are consumed when the ship is either in port or waiting off anchorage. You wouldn't be making a separate award for the bunkers consuming while waiting for orders. Now, in the Saranikos, they don't give an award on the basis of the demurrage rate. It's running costs, bunkers, plus the profit based on what the market rate would be for the vessel at that time. Now, a similar sort of situation arose in Glencore and OMV. As a CFR sale, the buyer, OMV, asked the seller, Glencore, that the vessel should wait offshore until a berth became available. Now, in this case, bunkers, the cost of bunkers consumed during that waiting period was awarded in addition. Now, that involves a second, rather, to my mind, rather dubious implied request in respect of bunkers, giving rise to a separate claim for reasonable remuneration. So, before the implied contract came into effect, OMV inquire about the demurrage rate. Glencore provides it to them. And the judge says, in the light of that, it seems to me that the demurrage rate became the implied contractual benchmark for quantifying Glencore's claim for providing the services of the vessel in the waiting area. It was the fair commercial rate and met the standard of reasonableness for the services Glencore provided. But, paragraph 56, there is one caveat to that. The request in OMV's email, the 9th of November 2015, about bunkers, that the master record them on arriving and leaving the waiting area, persuades me there was an additional implied term that OMV would pay for the bunkers consumed as a result of the vessel having to wait at the waiting area. Why else should OMV request that bunker records be kept, except that a reasonable person knowledgeable about this trade would expect that a claim for bunkers would follow the request for the vessel to wait? Not necessarily so. I mean, that wouldn't necessarily follow from the Saranikos. So you have to be careful what you ask about. You may find that there is a separate implied contract which stings you with the cost of the hotel bunkers consumed during the waiting period. A variant on this is a case called the Raguva, for a voyage from Houston to Monrovia in Liberia, and that's followed by the second discharge port, which is Douala in the Cameroons. So after the conclusion of the charter, Ebola broke out in Liberia, and on the 19th of August 2014, the master advised the charterers about the problem of Cameroon closing its borders to vessels coming out of Liberia. And the next day he proposed that it would be better for everybody if the cargo were to be discharged at Douala first and then to go to Monrovia. So this is a suggestion actually emanating from the ship owner. Charterers agree, and this generates an award for reasonable remuneration by the arbitrator John Schofield, who relies on the principles of the Saranicos. He awarded reasonable remuneration to reflect that change in the charter made by agreement, or in other words, on the basis of quantum meruit. And this was based on the time charter equivalent in the present charter, plus bunkers consumed during the voyage from Douala back to Monrovia. So the parties' correspondence about the change of rotation of ports generates a new agreement, and that's the basis on which reasonable remuneration becomes entitled to the ship owner for the extra services which have been provided by altering the rotation of the ports. So, to conclude this short talk, what's the solution about waiting? Well, you could always use a bespoke waiting for orders clause. Not entirely without its problems, though. How does this perhaps overlap with the late demurrage regime? And this is what happened in the Saliv Baikal. They've got this wonderful waiting for orders clause. If you're going to using the vessel as a floating warehouse, you get an accelerated rate of demurrage, which it sort of accelerates after certain predefined days of waiting. And what happened is that the vessel goes to Rotterdam, she gives notice of readiness, so the lay time and demurrage regime should be kicking in, but the charterers don't give it any berthing instructions, and the ship is just waiting at anchorage for about 67 days, effectively acting as a floating warehouse. Ship owners naturally say, well, we've got this particular clause about waiting. You owe us not just the demurrage, you owe us an accelerated rate of demurrage which is provided for under this clause. Not so. The clause would be triggered by a specific positive request by the charterers to wait. None was forthcoming. The charterers simply failed to do anything to enable the vessel to be able to proceed to berth and discharge her cargo. That case, I believe, is going to be the subject of an appeal shortly, and it has certainly generated quite a bit of interest. But the problem is that for the ship owners, notice of readiness has been given. You've got the lay time and demurrage regime. You're stuck with the demurrage rate for that period of delay while you're waiting for a considerable period of time for the vessel to actually be called into the discharge berth. So, thank you for your attention. There will be further talks coming next week. Goodbye.